Estate planning is really a very wide topic, and when people often call me and say, "Hey, I need help with an estate plan. Who do you know?" Well, I wish I could ask some questions, see what they're talking about, because they can mean a lot of different things. And we're excited to have today somebody back on our program. We've had several times, Attorney Robert J. Silverman, who can talk about the wide breadth of niches and some of the specific trends in estate planning. Bob, thanks for joining us again today.
Thanks for having me.
So let's talk about it. If you've been doing estate planning for a while, I forget for how many years. I want to say 30. You've been in law, right? I know for 30 years.
Since the dinosaurs roamed the earth, Bill.
Back when I started real estate, about that same time, I think I was down in another part
About
of the jungle.
32 years, yeah.
So let's talk about what would you say are one or two of the biggest changes in estate planning since, if you were to look back when you started, and you were to pop in a time machine here today. Wow, I can't imagine that change. What are the one or two things that pop out as major changes in estate planning since you started the practice?
Yeah, great question. There are a number of them. I'd say one is back, in the mid '90s when I first started practicing law and estate planning in particular. The federal estate tax exemption, that is basically how much assets you could give away during your life and on your death without being subject to this nasty federal estate tax, was $600,000. Today, it's $15 million. So very, very dramatic changes. So a lot of the folks who had relatively modest estates, called medium-sized estates back in the '90s, they did a lot of sort of more complex planning to structure things for potential estate tax liability. Nowadays, it's less than one tenth of 1% of the people in the United States who have a federal estate tax problem because the exemptions are so high. So the certainly one trend, big trend, is that there are other more important things for the vast majority of people than planning around estate tax. For example, building in good creditor and marital protection. That's a huge trend over the last 10, 15 years. And we pay a lot of attention to creditor and marital protection in our planning.
So let's go back to the first one because you're right. When I started in real estate before you, in the mid '80s, actually, a decade before, when there weren't even dinosaurs yet. You're right. The focus was on limiting or maximizing the opportunities at that time $600,000, and it seemed like estate planning was all about that. And now it seems like it's more of a whack-a-mole where the limits changed and recently were codified by law, but weren't. Is it going to be, not going to be? But then you have not just estate taxes, you have not just estate taxes, but you have state taxes in California. You have property taxes and reassessment issues. You have, as you mentioned, credit issues. You have, protection of assets. You have guardianships, conservatorships. It seems like that now estate planning is more of a whack-a-mole with a number of possible enemies or concerns or risks. And you, as an estate planner, need to have a more holistic or overview of the client's life than just merely, well, how much do you have? $10 million. Let's figure out a way to hide that. So it seems to me that your practice must have become more holistic or more interpersonal by the nature of the change of the marketplace.
100%. It is broad. A lot of people sort of forget about, they concentrate on living trust, and understandably, because living trust is still, the golden ticket to avoid probate. And I have a very robust probate practice as well as estate planning in my firm. But not that we don't advocate for that. It's just that there's no shortage of people who don't plan. And it's not terribly particular. It's not particularly difficult to plan so that your family can avoid a long, expensive, inconvenient court proceeding called probate. Doing a trust, there's a statute that says if you have substantially all your assets in trust when you die, then you get a pass on probate. And so there's a lot of focus, understandably, on trust, but there's not probably enough focus on the other important documents. Like you mentioned, people come in with minor children. They say, well, we have kids now, so we should do planning. Yes, trust, but what about guardianship? A huge deal. Guardianship nominations that is the will is an appropriate instrument to put guardianship provisions, not a trust. So wills are super important, not only for minors, but just in general. Powers of attorney and advanced healthcare directives. What happens during your life? Forget, aside from on your death, you got your will and your trust that are operate, but what about during your life if you become incapacitated and need somebody to step in your shoes, have legal authority to handle financial and medical things for you? That's a big deal. It's a lot more likely that, as you age, that you become incapacitated than you die prematurely. So there's not probably enough emphasis on that. So that's the broad scope, those 4 core documents. And then, of course, beyond just doing the documents, particularly, with the trust, is, okay, you signed your trust. It's been prepared. You worked with a good attorney. You have a great document. That's not the end of it, of course. Then this whole idea is, what do you do with the trust? Well, you fund it. You actually transfer your real estate and investment assets into the trust and keep it funded during your lifetime. And an adjunct to that is not just funding your trust, but do beneficiary designations for life insurance and retirement plans that are going to be governed by those beneficiary designations, if you have any, as opposed to being governed by your trust and will documents.
One of the things that strikes me over time, and as well personally, unfortunately, my father-in-law and then mother-in-law being incapacitated and needing the health directives, using the health directives, was that it seems like as fast as you can write good documents, the regulations change, the institutions become more rigid, more defensive, I think. It just seems to me that more particular. And so you can't necessarily paper your way out of a problem. You need to kind of, do your best to prepare. But something you wrote 5 or 10 years ago may or may not stand up if there's any change in regulations or any change in law. So talk a little bit about, I know people often think about, well, I changed my, I got married, divorced, somebody passed, somebody was born. Obviously, those are triggers for reviewing your plan. But I would seem to me that one of the issues also is just the change in the nature of laws, regulations, and institutions, and making sure that, particularly if you're incapacitated, you're going to want the right people to have the right powers. Otherwise, you're going to not be able to make the right decisions that you want.
That's right. Reviews are critical. There is some misconception out there, or myth, that once you establish the estate plan, you're good. It's a one-time deal. Nothing could be further from the truth. It's not like very few planners say, "Hey, come in every year and review it." But on the other hand, don't wait 15, 20, 25 years to review it. As you point out, Bill, there are tax law and trust and estate law changes that happen fairly frequently. And it's like anything else. If you don't keep up with it, and if you don't adapt and revise your documents accordingly, and most lay people, they don't necessarily have the tools to keep up with it. So you go see your estate planning attorney. Our benchmark is every 3 to 5 years or sooner if there are any material changes in your financial or your personal or family situation.
It's also making sure that the people you work with have that. I know my wife was recently at a major hospital, Cedars-Sinai, and they checked to see if she has health directives. Well, she did have one a long time ago, because the hospital would give you one, you would check out the boxes. We had our own done, but they had really the wrong one, I guess is the way I would put it, or they had the right one, and we had the right one sitting in a box here at our house. And so I think sometimes it's about also making sure the plan is ready to implement rather than just getting the documents done and not used. And that goes to, you use the word funding. As real estate agents, we've all heard the story, I've experienced it, where you meet with a customer and you pull the tire report before you go, or a profile, and it says, the home is owned by Mary and Bob Smith, who you're meeting with, or maybe it says Mary, Bob Smith, and Frank Smith, and you ask, oh, Frank's my father, my whatever uncle who owns it with us, so now you know who the players are. But sometimes you ask that question, they go, oh, well, but we own the property in a trust, and I look at the form and say, well, that's funny. I know my title company is not perfect, but I pull this profile. Oh no, we have a trust, and I'd say, are you sure? And they'll run back in the living room or the bedroom and or their office and pull out this beautiful book, and it's Naugahyde or leather with all kinds of tabs, all kinds of papers, and they open it up, and the first page is a letter from the attorney to the customer saying, "Don't forget to sign this and get it recorded." And it's not signed, it's not recorded, which really means it's not really. I mean, I'm not an attorney, but generally speaking, it means it's not really in effect. So talk about what does funding do, and what kind of steps do you take as an attorney to make sure that customers don't just leave your office with a beautifully bound book? I'm sure it's beautiful, but they also leave with a plan that's ready to implement.
Yes, indeed. In fact, just as an aside, I gave a talk last week to about 40 real estate agents at a very successful brokerage firm, and we talked about marketing, and for real estate agents, it's been somewhat of a trend. It's still a niche for agents to go down to access court records and see who filed probates recently. And if the probate has real property, they contact the attorney or the administrator who's on file, and it's open to the public, so you can find out who that is, and they try to get the listing. Hey, perfectly valid marketing opportunity. But I posed this hypothetical, this proposed change in the marketing view, or in addition to that, said to the agents, look, if you access in your farm, if you access in the neighborhood that you work in, records of titling, and you go down a list of 100 folks on a street or in a neighborhood, and you see who has their property titled in their trust and who just has it in their own names. Yes. And you contact them and say, look, I was looking, this is just sort of for your education, and just I noticed because I work in your area, and I noticed that you don't own your home in trust. Hey, I can send you a brochure or whatever. You might want to consider doing that. If you want a name of a good trust and estates attorney, I can give it to you. And you're doing a service. You're not saying, hey, I want to get your listing. Are you looking to sell? I mean, that's right. Traditional real estate, but right. It's a little bit different. You're providing a service. We service professionals. The best we can do, I think, is kind of value added. Hey, yeah. We don't know just about our area, but we know about a number of areas. We not only want to be your real estate agent, we want to be a trusted advisor. So that's just an aside. But getting back to the tools.
Well, before you go any further, for any real estate agent watching this, that's phenomenal. If you're going to farm, the biggest question realtors have is, well, what do I bring? Do I bring a list of the sales? Other agents do that. Do I bring a list of the active listings? They're not my listings. But what you're saying is, learn a little bit about value for that homeowner, and then share with them both what you know and a resource that might help them be more effective. And I've never thought about it on a farming perspective. I've always said the opposite, which is all your past clients, if you sold them a house, you know how they took title. And maybe at the time you're just worried about your commission, and it is hard to get a customer to start an estate plan when they're buying a house. I mean, there's a lot of moving pieces, and sure. I understand we don't overwhelm people, but there's no reason not to go back through your database and take everybody who owns a house and say, how do they have it titled? And all those who don't, like you said, I teach this all the time, the best free marketing, call everybody you know, check public records, do they own a house? If they do, is it entitled or not? And if it's not, offer them to some resource. And it might be, hey, I saw this great podcast with Bob Silverman, and he's a local estate planning attorney. Or maybe you have another one that you like better that's, if you can imagine a better option than you. I don't know there is such a thing. And I think the other part is those who have plans, I always tell agents, ask them if they're happy with the attorney. Because I find half the time they'll say, oh yeah, Betty Boop, she's the greatest. Now you have another excuse to call Betty Boop and say, hey, my clients Bob and Mary say you're the greatest. I thought Bob Silverman was, but maybe you are. Can I just chat a bit about how you serve your clients, and maybe we're a fit? But half the time they say no. And by the way, I've had this happen personally. And I needed my plan updated because now we're divorced, now we're married, now we have more kids. Do you know somebody? And so these are things that when you really dig in and seek to create value for your customer, you go from just being a real estate hack who's cold calling, leads, to really saying to somebody, hey, I care about you enough to look up public record information and to try to help you with it. So that's a fantastic suggestion, and I would take it a step further, make sure we talk to our own current clients.
Bill, that's a great point, is that, hey, cold calling, if you will, is fine and it can be worthwhile. But warm marketing, following up with clients who you've already done business with, hey, that's a great excuse. So that's an excellent point. The back to sort of resources and funding. The fact is that transferring assets into your trust, people sometimes don't get good advice or they get complacent. So they fund their trust, they transfer assets into the trust, but then they buy another piece of real estate. And then they forget, oh, I did a trust 3 years ago or 10 years ago, and I forget we're supposed to take title in our trust, and we didn't do that, okay? So, and then they intend to transfer it into the trust and something happens and they're gone, all right? So we like to build guardrails, and there's two ways that we help clients build guardrails so that if something happens and they haven't fully funded their trust and therefore they're vulnerable to a probate, there's a couple of things that they can do that can help prevent a probate, avoid a probate. And one is having an assignment. We do an assignment for 100% of our clients, which says we hereby assign all of our assets of whatever kind, real estate, business, partnership interest, bank accounts, investment accounts, into our trust, and everything in the future that we acquire, okay? So, and they sign it. It's a one-page form. It's pretty simple. But that form, that assignment form, after the fact, they forget to put a piece of real estate in their trust, but they've signed this assignment. They're gone. Their relative now goes to an attorney, and the attorney says, I can go to court with what's called a Hegstead petition. I know, Bill, you're familiar with them. A lot of listeners may not be, but a Hegstead petition is basically going in to court and saying, well, this decedent intended this asset to be in the trust, but it didn't happen. But we don't want to have the family suffer to go through a probate when it's otherwise avoidable. This assignment is good evidence of that intent. And most judges will take that and say, yeah, that's good enough. We will deem that it's in the trust, even though it didn't actually get transferred. One other similar tool is schedule of trust assets. So if you have a schedule of trust assets, and even if you didn't actually transfer it, and you put down on the schedule 123 Main Street, and it says schedule of trust assets, the Bob and Mary Jones revocable trust, again, that and or the assignment can go in to court, and for a few $1,000s, and in 3 months, you've got an order that says that is in your trust, as opposed to a $15,000, $20,000, $25,000 probate that takes a year. So scheduling your trust assets, transferring them, of course, first and foremost, but just in case they don't, or the classic example is somebody puts their home in the trust, but then they refinance.
Happens all the time.
And the lender says, no, we don't want to deal with your trust. You got to take it out of your trust. They do that, and how many people forget to ever put it back in? That's a common example. But again, if you've scheduled it, then that's a safety net for you.
So just a little color to this, because this podcast is national. The Hegstead petition, Hegstead is a court case in California that found that the court has the ability to determine the decedent's intention. And so that's what Bob's talking about, is proving that intention. To my knowledge, that doesn't exist in any other state. That's uniquely California. We have a unique laws, and that's one of them. And the other thing I would say is a little different in Southern California, because I know, Bob, you're more in Northern California, that while people say, oh, it's no big deal, I can get a Hegstead petition. Well, in California, in LA County, that's a 6-month filing minimum today. You file your hearings out for 6 months out. Yes, there is ex partes and extenuating circumstances, but generally speaking, and it's not as expensive as a probate, but it's not cheap. So I guess on one hand, I'm glad that we can share this for people in that situation. Call the right attorney, call Bob, and you can get your property put back in the trust or whatever has to be done. But for the rest of you, don't consider a Hegstead petition as part of your estate planning tools, because you really don't want to. The whole point of the system is to avoid having to go to court and depending on the judge and spending the money. We want to do it the right way. And Bob's pointing out some guardrails that makes his plans more effective, but we really don't want to do that. We don't want to hear Bob and go, oh, great, I don't have to worry about anymore because
Yes, that's a worthwhile point to emphasize for sure. There's nothing like fully transferring your assets, transferring your assets in any state. This is going to apply where just doing right, establishing a trust, signing it is not enough. You actually have to transfer substantially all of your assets. By the way, I use that term, and sometimes people say, "Well, what do you keep saying substantially all your assets? You don't have to transfer all your assets. What are you talking about, Rob?" Well, so what I say is, I tell people, look, the legislature in California, and there are similar statutes in other states. The legislature provides a cushion. The real world is that almost nobody puts every single asset in the trust before they die. So you die and you have your real estate in the trust and you have your investment accounts in the trust, but you have an automobile and you never went down to the motor vehicles department, whatever it's called in your state, and transferred your car into the trust. That's okay. It's okay here, and it's okay in California, and it's okay in most states, because there's a threshold of assets, total assets, that you can have just in your name, in other words, outside of your trust, without triggering a probate. In California, they just increased that number. It's $208,850, a weird number, but so it's a pretty good cushion. So you're not automatically going to go into probate. So you do want to concentrate on getting, of course, all of your real estate and the bulk of all your investment and bank accounts. But you got a little checking account, you never keep more than a couple $1,000s in, and you have an automobile, and those aren't in your trust. It's usually in virtually any state. That's going to be there's going to be an abbreviated, much abbreviated, fairly inexpensive procedure without going through a full probate to get that to your loved one.
One of the issues that can come up, it's a little more sophisticated, but on larger estates, is kind of the blending of separate property and community property, right? You have somebody maybe who has a previous marriage and they accumulate certain assets, and maybe they have children from that marriage that they want to designate some of those assets for, and they get remarried and they now have new kids. And I think there's a little misnomer that, you can't have any kind of blended plan. But I believe you can have a blended plan, just accommodates and identifies assets separately. So talk a little bit about how somebody who has some separate assets and has some community assets might go about protecting their desire of how those things are distributed.
Yes. So the another myth is that you must have two different trusts, a his and hers trust. You can't just have one revocable trust if you're married and you either has separate property as opposed to community property. At least in California, it's community property. Different other states have all sorts of different characterization of property, and the rules are very different. But here in California, community property is you acquired the assets during the marriage. Separate property is you owned it before marriage and brought it in, or you received a gift or inheritance during the marriage and it was just you. That's separate property. With a joint living trust, you can hold community property and separate property. Check in your state if you're not in California, but you should be able to have one revocable trust in which you have both separate and community property or joint marital property in one single trust. That doesn't mean you have to do that. I have clients who have a joint trust, married couple, but one or both of them have significant separate property. So one or both have separate property trusts as well. You can have more than one trust. So, and there are a lot of different factors that govern whether or not that's a prudent or necessary thing to do. But you can have separate community property. And, most people think, okay, as soon as I've taken, I inherited this account with, $250,000 in it, and I put it into my joint trust, I've tainted that. It's no longer separate property. Again, check your state law, check with the state planner. But here in California, just putting it into a trust doesn't change the character of the property. It can, but how do you distinguish it? You can have schedules. Again, you can identify his, Bob's separate property, Mary's separate property, and joint property, and you can have different schedules so that it can be identified. You can also do a little tagline with a brokerage account or whatever, or a piece of real estate that says, Bob and Mary Trust, FBO Mary as her separate property, FBO for the benefit of. So there are different ways of putting it into a joint trust, but still distinguishing it as one spouse's separate property. Again, check with your attorney in your particular state about that.
So let's pivot a little bit in the last few minutes. As I'm coming to the end, we talk about the business side of it a little bit. You've been in this business for quite a while. You've established a successful business. You do estate planning, and you do some probate work as well, probate administration. Attorneys, I find when they start out, start and point broadly over many different topics. And I know when I make referral to somebody, I'm always looking for somebody who's a specialist, because I feel like the customer is going to get much better service from somebody who really knows one niche area. Talk a bit, what would you recommend to an attorney starting out in business as far as finding that niche, finding the area that they're going to work in that's both going to be deep enough for them to be successful, and yet they'll be able to find that and broad enough they can have some business?
Yeah, that's an interesting question. I mean, most people know that regardless of the field, we've become a world of specialists, and that can be very, very valuable. On the other hand, there's value in just doing just good basic planning. Among the huge numbers of folks don't have any particular very specialized need. They just need good core documents. So with the transfer of wealth in the last 10, 15 years and the coming 10, 15 years, baby boomers who are dying and so forth, that the transfer of wealth is in the trillions of dollars. There's no shortage of work for a estate planning attorney. It's not an easy area. There's a lot to learn. And if you get into advanced planning, which I'm involved in as well for higher net worth clients, as well as core planning, then you've got to do you've got to learn a lot about sort of more sophisticated tax aspects. But there are a number of specialties that you can go into where there's plenty of work. Special needs planning is one of those. Public benefits. If you receive public benefits, there's a lot of special needs trust planning that should be done so that basically special needs beneficiaries can enjoy inheritance and can enjoy assets without jeopardizing their with entitlement programs like SSI and Medicaid. Those are means tested. And if you just have assets that are available to you because you happen to have this inheritance, that's going to jeopardize your public benefits. Whereas if they go into a special needs trust that's been created, and it's done, drafted and done properly, you can have your cake and eat it too. You can enjoy those funds for special needs without jeopardizing your public benefits. That's a huge area. Elder care often goes alongside of that. So that's an area of specialty. If you want to, and you're good, international estate planning. Lots of folks have property in other countries and so forth, and the laws are very different. That's quite specialized, and there's very, very few planners who do international planning. So there are some niches within estate planning, but there's also plenty of opportunity for newer attorneys to go into estate planning and thrive, even if they don't have a super specialized focus.
One of the kind of ancillary services to estate planning, probate administration, are fiduciaries. In California, we have a series of professional licensed fiduciaries. In other states, they're just fiduciaries that act as third parties. And I think oftentimes, they're needed more than they're used. I find that attorneys are maybe hesitant to recommend them because there's an expense to it. But on the flip side, I also see the customer is overwhelmed when they try to do the work themselves as the administrator. Those who are fiduciaries tend to be older or aging out. I don't see people entering into that business. And so just talk a little bit about how are you involved with using fiduciaries on behalf of your estates and clients? Is it something that you see a growing need for, or is it something that maybe just it's static? I mean, at least my perspective seems to be, as estates get bigger and the litigation gets more complicated, there's more needs for somebody who's professional to sit in the middle rather than just a family member who is designated.
I agree with that, Bill. I think there's a growing need. There have been a lot of folks here in California who have become licensed private professional fiduciaries. And about, I don't know, 15, 18 years ago or so, there was a statute in California, a whole statutory scheme where you used to be able to just hang yourself. Could have no experience at all, and you could hang your shingle saying, "I'm a private fiduciary. Name me as successor trustee of your trust or as agent under your power of attorney." Nowadays, in the last couple decades, there are educational requirements, and to get licensed, you have to be insured and bonded for the work that you do. There's plenty of opportunity, and I think the more estate planning attorneys, realtors, financial advisors, insurance advisors learn about this, the more valuable and the more they talk to their clients and their colleagues about it, the more private fiduciaries will be used. And the classic example is talking to a couple, and they have 2 kids, and they say, well, talk about who should you name as successor trustees of your trust. Well, we have 2 kids. I don't want to pick sides. We're going to name the 2 of them. Because either one would be really upset if I just named one.
Sure.
Well, so I'm going to name them together. Do they get along well? Oh no, they fight like cats and dogs. Oh well, then okay, then that's a great idea. Let's go ahead and name them, right? And let's see if there's a big battle. So they don't have other relatives or good close friends that are good candidates, and they don't really want to choose their kids. They want to have a neutral third party. That makes a lot of sense in a lot of situations. And as you mentioned, Bill, the more assets you have, the more sort of protective you are. And so you want somebody to do it neutrally, objectively, somebody who has experience, as opposed to maybe your well-meaning child or grandchild or sister who just doesn't have the skills to do it. So I think it's a growing need. I use private fiduciaries and recommend them in not only core planning, but also in advanced planning, where we're setting up specialized kinds of irrevocable trusts and being set up now. So somebody wants to gift their assets into a specialized trust that's effective now, right. But for some tax reasons, the people who are making the gift, they're not the appropriate folks to name as the trustees. So we name a private fiduciary to handle that. So big need, and the more people understand about the advantages of naming a fiduciary, the more growth that we're going to have in that area.
Yeah, I see more and more in larger states that they're moving more towards professionals, and I think things go much more smoothly. Whatever fees they charge, they seem, in my experience, to save and reduced litigation expense and then better yield. I just did a deal the other day where a fiduciary kept money in a CD for 4 months. I don't think a non-professional would have thought about it, and it was like $1,200. And maybe he billed for a half hour of his time, but he brought the estate back, $1,200 of money sitting there just for 4 months while we're waiting for something to happen. So these are things where I think professionals, yeah, you can do it yourself. You just don't want to do it yourself. Last question, if I can. The hottest topic in real estate is artificial intelligence. If you want to fill a room at a convention, talk about it. It seems to me, and I'm big into tech. I use all the platforms. I'm using stuff all the time. It's become my new hobby. But it doesn't seem yet to be transformative. It seems to be empowering, and most of all, the tools I already have. I feel like I'm getting more powerful use out of my MLS and public record information and other things. Talk a bit, as an attorney, estate planning attorney, where is artificial intelligence affecting your business, your practice today, and what are you doing today maybe to just safeguard yourself that you're going to be relevant or stay up with it over the next few years?
Yeah, that's a great question. Of course, AI is on everybody's radar, and I think in the law, the resources that we have, the educational resources and tools that we have, all of the big ones, they already have AI firmly incorporated in those programs, right? So it's just the way of the world. But just on a relatively casual basis, I mean, you have to, I attended a virtual seminar on AI maybe 3-4 months ago, and the overriding theme is trust but verify. Okay, so there's a lot of they call hallucinations, right? And made up stuff, and there are examples, and I'm sure some people who are listening today know of there have been cases where attorneys have cited legal citations for cases that they've gotten hammered by the judge because the case doesn't even exist.
Yeah. More than
Or
hammered, I think really, really called on the carpet by the judge in one case I saw.
absolutely. So you have to be careful, but the efficiency with which we can help people, if there's research that's merited in a case, but it's not a $1 million problem or maybe $100,000 problem, but it's an issue. The AI resources that are there, as long as you verify, can plug you right into almost anything very, very quickly. And for attorneys, this seminar, again, that I went to, and there are many like that, says, older attorneys and folks who've been in this field for a while often say, that's for the next generation. I'm going to ignore it. I'm going to hide my head in the sand. And the emphasis there by the presenter was, you can't do that anymore. You can't do that anymore. Why? Because you could get sued for not not having them, not at least understanding the available resources. It doesn't mean you have to use it in every case, but to just sort of ignore it is potentially committing malpractice on the, and so you can no longer hide your head in the sand. You need to plug in and at least have a general knowledge about resources that might be available to your client and to you for the benefit of your client. So very, very interesting.
For me, I can put in data and have it analyze, let's say, closed cell data and create an analysis on the data I give it. But what it can't do, it's interesting, it can't access Zillow and Redfin and other online because those websites block the AIs because they don't want them scraping their data. Yet the AI will come back with an answer from Zillow, and I'll check it and it's wrong. And it thinks it's supposed to have an answer. Maybe it was an answer that got on that property 9 months ago or something, but it's not accurate. And so it's one of those things where I can use it for summarizing my own data, but I can't really use it fully for data that I don't really understand or have any access to. And it sounds to me like as an attorney, it's the same thing, that you can maybe synthesize some things that you've put together, but still not in a position where you can really rely on, let's say, pulling up cases. I would think that'd be the most dangerous, pulling up case citations. If you don't check them, and then my experience is if you check them, you're probably going to find a few of them are wrong. Well, if you pull 100 case citations, you check 2 or 3, and at 20 and 2 or 3 are wrong, what do you have? Who knows what the other 80 are like? So is that kind of where you're at with it, where you can use it for stuff? I just don't think it's certainly not replacing me. I don't think it's replacing you anytime real soon. It's going to empower us if we use it properly, I think.
I agree with that too. Yeah, it's interesting. I first started using it a few years ago. I write this monthly article, and I have been for probably about 25 years. Put it into a local publication each month, and then I reprint it in an email newsletter, and then I send out to couple thousand people each month. And so I met with somebody and say, "Do you know about this AI? And there's ChatGPT and blah blah blah. Hey, you write this article every month. You should use that to generate." So I tried it, and this is again in the earlier stages. I tried it, and I was plugged in. I wanted to write an article about sort of the estate planning blunders that have been made by famous people. And so I said, give me a 700-word article on this. And in 10 seconds, 15 seconds, I had a 700-word article. It's like, wow, this is fantastic. And I went through and I checked, and it said this is what happened with this particular celebrity. And I checked it, and it was, in some cases, it was absolutely wrong. I mean, not even close. And others, it was close, but it wasn't correct. And so I went through and I had to correct. I did have a great start on it. Okay. Yeah. So this is what you're talking about. Hey, you can use it as a resource, but keep the brain on and do some further digging, because it's hardly perfect. And also, it's not necessarily your style. You can have something that gets spit out that may be even accurate, but it doesn't necessarily convey what you want or in the style you want. So useful tool, but we're not being replaced anytime soon.
Yeah, I don't see it. It's interesting. One time I did try taking, so I do an email every week as well. I write out, and then I video it and send out in video format as well. And so one time I did the opposite. I did the video off of kind of an outline, and then I used AI to rewrite it into the email. And I had 3 people right away said, that's not you. Because my writing style is unique, and I think that's the thing that we want to leverage is our unique, connection with the people who hear us and appreciate our style of communication. And if ChatGPT could replace us, replace all of us, it can't replace me. It can replace somebody who's not as good as me, but it can't replace me as long as I'm good and better than ChatGPT. So, well, good. I think we're on the same page there. Rob, always learn a lot from you. I really appreciate your time today. For those who want more, let's see here, silvermanjaffe.com is the website, and there's a phone number there, as well as we have contact information here for him as well, phone number and email address and website. And thank you so much for taking time today to teach us about more some of the details of the estate planning issues and how we can be more effective in providing for our clients. Really appreciate your time today.
Thank you, Bill.
And for the rest of you, this is Estate Planning Weekly. We get together every week, usually with an estate planning attorney, oftentimes with vendors or other people who help us be more successful in our business. Whether you're a real estate agent or an attorney or other professional, we want to learn how to be more effective in helping our customers achieve their goals. If I can help, reach out at Bill Gross Probate on social media. As always, make today your best day ever. Thanks so much.